All right. Hello, everyone. Hello. Welcome to my live. This is immigration attorney Moumita. I'm so happy to be here today with all of you. Just a quick word, I'm live streaming on 4 different platforms. So I'm on TikTok, Instagram, Facebook, and YouTube for all of my loyal followers, my friends, my colleagues. Thank you so much for watching, and it's my pleasure to be here today. So let's jump right into it. Please let me know what immigration questions you have. Drop me a comment, leave me a question, whether it's immigration related or maybe even something else, let me know what it is. So one question that I have gotten a lot today is, how can I help my immigrant mom or dad? How can I help them get a green card if they're here, undocumented, without papers, without status? What can we do to help? So this is a really important question because, of course, as kids, we want to do everything that we can to help our moms and help our dads. But the most important thing to keep in mind is, did your mom or did your dad enter into the country legally? If they entered into the country legally and you are 21 years old and you're a US citizen, whether by birth or by acquiring it through marriage or some other way, then you are considered to be able to apply for your parents immediately for their green card regardless. But the other big question is, what if your mom or dad does not have a legal entry? What is the possibility of helping them fix their status even if they do not have that legal entry? For this, it's a little bit more complicated. We really need to look to see what other factors are at play, whether they have the permanent bar, whether they're eligible for any other sorts of relief. And the good news is that there are actually several different case types that a person might be eligible for that would allow them to get a green card even if they don't have a legal entry. But it is very, very dependent on each case. So really requires me to look into each person's history, look to see what applications may have been filed in the past, whether there are any military family members. So there's a lot of things. So definitely the best way to get started is to book a consultation so that I can take a look at the parent's history, talk to them, ask them a bunch of questions to see what they might qualify for, okay? So if you do want to talk about your parents, 212-248-7907. And I had an excellent question here on TikTok from Hydra Tequila, who is asking, what makes somebody have a permanent bar? Like, how many entries without inspection? Great question, Hydra Tequila. Thank you for that question. So anyone who has had a relative who's been back and forth between the border may have been told that they have a permanent bar. And if you've heard about this, then it sounds really scary. The permanent bar is something that is actually very, very serious in immigration law, but there are many things to keep in mind. So first of all, the permanent bar is basically triggered. You trigger the permanent bar when you re-enter the United States after having been in the US for more than 1 year, after April 1st, 1997, and you basically accrue more than 1 year of unauthorized presence in the US after April 1st, 1997. So that's the key date. And you basically re-enter the US after having that 1 year of unlawful presence after that date, or you have an order of deportation and you re-enter again. And the important part is that you need to have entered without permission that second time. So it's not really about how many entries you have, but rather when they occurred and how long you were here before you made that entry. So Hydra Tequila, I'd be happy to take a look at your case. Now, this is the important part. There are actually 3 different types of cases that a person, that I usually screen people for to see if they might be eligible to waive that permanent bar. Because even though the name itself says that it's a permanent bar, it's not really permanent, so to speak. There are actually 3 different types of cases that may help you waive that permanent bar. But as I mentioned before, it's really on a case-by-case basis. Everyone's individual facts really determine what they're eligible for and whether they can fix that permanent bar. And if they can't fix it, then really, the only other way is to just leave the US for 10 whole years and then come back after that. Then by then, the permanent bar is basically expired, and then you can come back, all right? So give us a call if you need some help. Okay, I have a question from Jogi. 4423, how long does it take USCIS to mail out approval notices after getting the I-797? So approval notices can take anywhere from 1 week to a month to get, but also it really depends on the decision, because sometimes we'll have an interview on a case and you may not get a decision after that interview for many months. If many months are passing by after you have your interview on a case, it's time to take some other actions. Sometimes it happens in some of my cases, and we have to do some extra work to try to get USCIS to make a decision. Sometimes, though, you have to actually sue the government to get a decision. Okay. All right. West Coast Babes, Momster Doll is asking, how much is it to start to fix? West Coast Babes, first of all, if you're interested in speaking with me and having me look at your case, first thing to do is to book a consultation by calling 212-248-7907. I do have a fee for consultation, which is $150. There is no free consultation. But then once we consult, once I go over your case and to see what you might be eligible for, that's when I can give a fee. All right. But I'd be happy to talk. Okay. I have a question from Rwandan community of Washington. Can someone who has filed for asylum and their case has been pending for 5 years without interview, can a company still sponsor the person for a green card? Very good question, Rwandan community of Washington. Thank you for watching. All right. So if you have filed for asylum, the first question is were you in status at that time? Do you have any alternate status available now? If you filed for asylum 5 years ago, then presumably you may already be out of status because you didn't have anything going for you in the first place in terms of a legal immigration status. However, if you now have a company that's interested in sponsoring you, then we have to look at a couple of different things, such as, how much unlawful presence do you have? Can you possibly do a visa outside the US? It's a little bit more difficult. If you have already been here for 5 years and a company is now looking to sponsor you, whether you filed for asylum or whether you're waiting on something else, it is actually going to be very difficult and will usually require you to depart the US to get a proper visa stamp in your passport. If you filed for asylum, that may not be possible. And also you may need a waiver to come back to the US, depending on how long you were in the US without permission. That will be a little bit difficult too. Okay, so let's see. I have a question from Mameng Eliza, who's asking, what's the difference between a T and a U visa? Mameng, thank you very much. That's a great question. So a T visa is a visa that is for victims of severe forms of trafficking, and trafficking can occur through the most common way that people think about trafficking is sex trafficking. So if you're forced into prostitution, for example, the other form of trafficking is called labor trafficking. And labor trafficking is when you are in a job environment or you're forced to provide services or labor underneath duress, underneath force, underneath threat. You're not really free to leave, or the employer can keep you there with deception and things like that. That is a T visa. A U visa is slightly different. A U visa is for people who are victims of certain qualifying crimes. And certain qualifying crimes, usually they need to rise to the level of a little bit something more serious. But in both cases, you do have to cooperate with law enforcement, except for a U visa, you need to actually get the law enforcement agency to sign a certification, and that's how you get it. Now, in both cases, once you get a T or a U visa, it is a pathway to a green card. And, remember what I was saying before about cases where you might be able to waive the permanent bar? Through both of these cases, you may actually be able to fix your permanent bar if you get approved for either a T or a U visa. We do have to do certain additional applications, but it is possible. So give us a call if you believe that you might be eligible or you want me to take a look at your case, 212-248-7907. Okay. All right. I have a question from RB who's asking, hello, how long does it take to get an EAD after filing an I-360 and I-485 concurrently? Great question. And I'm very sorry, my camera is a little out of focus and I don't know how to fix it. But if you file an I-360 and an I-485 concurrently, nowadays, what we're seeing is that the work permits are taking about 5 to 6 months to get back, which is great news. That's actually faster than some other cases like the regular adjustment to status cases where the work permits are taking sometimes up to 8 months to get. But definitely we're seeing about approximately, más o menos 6 months, okay? All right. I have a question from Tyrell Collett who's asking, I'm currently in removal proceedings. I'm from the Bahamas and I overstayed my time. I got arrested and my case got dismissed. What can I do to help my situation? Okay, Tyrell, now is a great time for you to talk to your attorney to see if possibly you can request prosecutorial discretion from the ICE attorneys in light of the new interim guidance that was given by the president to the Department of Homeland Security, saying that the ICE attorneys should exercise their prosecutorial discretion in deciding whether to administratively close or to terminate or agree to dismiss proceedings against a person. Now, if you were put into proceedings because of a criminal act and now the charges have been dismissed, then presumably you don't have that aggravating factors, but you still have to show other mitigating positive factors in your case. I'd be happy to take a look, Tyrell, 212-248-7907. This interim guidance giving prosecutorial discretion to ICE attorneys is great. It is amazing. It is a signal to the government that they should consider humanitarian factors in keeping people together and keeping people out and getting people out of removal when they don't really need to be there. And it reminds the government that the main priorities for prosecuting people to be deported from the US are people who are national security threats, who pose a danger to public safety, or who were apprehended at the border as of November 1st, 2020, okay? So you can give us a call. All right. Name is Sosito. It's asking, my brother-in-law is married to a U.S. citizen and his lawyer said that he has to go to Mexico and he has DACA. Help. Okay. Name is Sosito. I would love to talk to your brother to see what he qualifies for, because while it is true he may need to have a waiver, he might also be eligible for other case types. And one thing that I look at, because one of my priorities is to try to keep my clients in the US and not have to process outside the US if they can help it. So I look at certain different case types where I look to see if there's any problems in the relationship. I look to see if they're eligible for, for a visa as a victim of crime or as a victim of trafficking, or if they're eligible through any other ways to be able to remain in the US to get the process done instead of having to depart to Mexico, where, as we know, the wait time is a very long wait. And also, there's always the danger of getting denied and not being able to come back. Also, we have to make sure that your brother does not have a permanent bar. I'm sure all of you have seen the news of certain DACA recipients traveling outside the US and not being able to come back for 10 years because it turns out that they actually have a permanent bar because the mom and dad may have brought them in and out of the US at a young age, okay? Permanent bar still applies to you even if you were a minor at the time of entry, all right? Arakskaya is asking, what if only one parent of the undocumented person is a citizen? Can you waive the permanent bar? Very good question. So having a parent does not necessarily help you waive the permanent bar. You have to independently qualify to waive the permanent bar through certain case types. The main case types that I look at to help waive the permanent bar is VAWA, which is based upon extreme cruelty or physical abuse, T visas, and U visas. These are the three main case types that I look at to see if we can possibly waive the permanent bar for a person. Having a parent be a U.S. citizen is not necessarily the only thing, or it doesn't necessarily help, okay? So Dimple Singh's asking, hi, I'm married to this citizen and I have a criminal history. Well, I can pay for my papers. Is that okay? No, I don't. Definitely do not engage in fraudulent marriages. Fraudulent marriage is one where you marry somebody for money and in order to get papers. I don't recommend that at all because there's severe penalties and the government can usually tell when it's not real, despite your best, whatever you think, the government can tell. All right. Ryan Tom's asking, what documents should you take to a lawyer to fill out the green card application? This I can't answer because every lawyer is going to have different requirements, but you should take whatever the lawyer asks you. Generally, you need to prove your identity, prove the marriage. Any past divorces, you have to bring the documentation that those prior marriages are final, certificates of kids, that were born to you either in the marriage or outside the marriage. And as well, you need to bring proof of your marital relationship to show that it is a good faith marriage. All right. Let's see. Nia is asking on Instagram, is there a backlog for New York marriage green cards? Yes, there is a really, really large backlog. In New York, the interesting thing is that in the same building, we actually have 3 different offices for immigration, and they correspond to the different boroughs of New York. So we have a field office for New York, which includes Manhattan and Bronx and the White Plains and Staten Island. And we also have one separate for Brooklyn, and we have 2 offices for Queens. Each of these offices actually have different processing times. Queens is the fastest. Long Island is the fastest, then Queens, then Brooklyn, then New York. So your case, depending on where you live in New York, it can take anywhere from 6-7 months, sometimes 8 months, to a year and a half. That's pretty much the backlog that we're dealing with right now. Sheikh bin Talib is asking, I had a domestic violence case which was dismissed, and I filed for VAWA, and my I-130 is still active. What to do? So if your I-130 is still active, you really have no control over that, because the I-130 is actually the spouse's case. It's not yours. So if you file an I-360, you can't really do anything to affect it. But maybe you can you can write to USCIS saying that you're no longer interested in being a beneficiary of that. I'm really not too sure what you can do. But anyway, filing an I-360 does not impact your I-130. They can both be processed independently of each other. Mehmet Kurd is asking, what will happen if USCIS denies my I-485 while I'm out of the US with an advanced parole, So if you're traveling on advanced parole and your I-485 gets denied while you're outside, you will not be able to come back. You will be denied entry. And one of the things is that when you travel on advanced parole, you are always taken aside to secondary inspection by CBP, because while you're in secondary inspection, they actually check to make sure that your I-485 is still pending. Because if it's not pending, if it's terminated, that means your advanced parole is no longer valid. So if you believe that there's a risk of your I-485 getting denied while you're traveling, don't travel. Come back immediately and get yourself in the US, because if it's denied, you're going to have a hell of a time coming back. All right. So Floor is asking, what qualifies you to go to Juarez for the interview? All right. So if you are traveling to Juarez from the US, most likely you are having to do something called the perdón, or the I-601A waiver, for a provisional waiver for unlawful presence. And for that, you have to prove that your US citizen spouse would suffer extreme hardship without you here in the US. And that's why you need, basically you're basically waiving in advance your 10-year bar from being in the US. That's what you're doing. That's what would usually qualify you to go there. But even before that, you need to show that you're the beneficiary of an approved I-130 application, which is for spouses of US citizens, spouses of green card holders, or children of US citizens and parents of US citizens. But only spouses and children of US citizens and green card holders qualify for the provisional waiver, if that makes any sense. All right. Name associated is asking, I have DACA and I want to apply for advanced parole. I heard then I can get my green card. Is that true? Very interesting question. Thank you for that. So if you have DACA and you want to apply for advanced parole, what that will do is that it will then give you a stamp in your passport showing that you were admitted into the US after you used advanced parole. But this by itself does not get you a green card. You still have to qualify for a green card independently of that. It just means that you may not have to do the waiver to leave the US and to go to Juarez, for example, for that interview that I just talked about. TikTok fam is asking, if I apply for an I-485, do I get the EAD beforehand? Yes, you usually will get it beforehand. Hello to everyone. All right. So Cubana is asking, my cousin was expedited was removed with an expedited removal from the US and is given 5 years. Should she try to reapply for permission to enter the US next year? Okay, so if someone was given an expedited removal from the US, then they need to have basically they're going to need a waiver to come back if they're trying to come back before the 5 years. And to qualify for this waiver, you're going to need to have a US and usually an immediate US relative, which is a spouse and a child or a parent. I can't remember exactly off the top of my head, but if your cousin does not have that required biological relationship with a family member that would qualify them for the waiver, they're going to have to wait the full 5 years before they can come back. All right. Okay, so I'm going to answer one more question and then I'm going to go. So this is an important question. Saim Ayan is asking, hi, how are you? I have a question on my asylum case. Immigration officer referred to judge. So my hearing is coming up in August, and I don't have an attorney because of financial problem. Okay, well, Saim Ayan, what you can do is you can go to the judge on your first hearing date and you can request, the judge to give you a little bit more time to find an attorney. It's going to depend on the judge. Some judges may give you some time, some judges may not. Some judges may just give you the final hearing date. If you're having financial difficulties, I'm really sorry to hear that, but I will say this. If you are in immigration court, now is the time to hire an attorney and get a good attorney. Because if you are in deportation proceedings and you don't have a lawyer by your side, your chances of deportation and losing your case are substantially higher. You have a better chance of getting approved for something at least with a lawyer. If you don't have a lawyer at all, then your case is much more likely to be denied by the judge. And this is, I don't have an exact statistic for you, but I know that it's the case. And it's really, really sad because, I know that lawyers, we are expensive. But one of the things is that we do a lot of work, and we do a lot of work, at least I do a lot of work on my cases, which is why I end up having to charge fees that might be unaffordable to some people. But if you really can't afford a lawyer, then, there are some legal services available. You have to search for those nonprofits where they provide free legal services to immigrants, okay? Catholic Charities is one, and there are many more, all over the US. There's some amazing organizations that may be able to help you, okay? So that's it. I'm going to go. I thank you all so much for watching. Please tune in next time. I hope to be able to answer even more questions. And if I did not get to your question, please have some patience. You can send me a message on IG and ask the questions there, and I'll try to address the next time I'm on live. And if you're looking for a consultation on your case, for an evaluation to see what your options are, to see what's right, what's going to work, what's not going to work, give us a call, 212-248-7907. I know my assistant Josue is standing by to book people for an appointment. All right. Hope you have a lovely, lovely day.